Hello, everyone. To those who are already joining the webinar, we'll be getting started in a moment. I'm going to put a timer on. Thank you for joining. We're going to give everyone a couple of minutes to join from around the country and around the world, for whoever it is. So you'll see the clock tick down when we hit zero. Mike and I will be excited to talk to you and tell you a lot about what's happening in immigration land. But until that time, just make yourself comfortable and get a cup of water, a cup of coffee, and we'll talk soon. All right. Thank you, everyone. Let me just get a couple of things out of the way. Welcome to the Melter Hellrung webinar for April. We'll be talking about compliance and trends. Um, we welcome questions. If you have questions, please put them into the Q&A, not into the chat. Please keep your questions general, not specific to a particular issue. Uh, we will try our best to answer as many questions in real time as possible. If you don't get your question answered and you are logged in with a name here, we will follow up with you afterwards. Um, this, of course, is not legal advice. Mike and I are both lawyers, but this is meant as general guidance. Do not take it as the end all and be all for your particular program. Please speak with a Meltzer Hellrung attorney or another attorney about questions that are specific to you. So let me just tell you a little bit about who we are. Meltzer Hellrung, we are uh, full-scale business immigration law firm. We really focus on exceptional service to both employers and their employees, recognizing that immigration is stressful and trying to make immigration as low stress, even in this environment, as possible. We represent well over 200 clients. We represent clients in the Fortune 500, Global 200, as well as entrepreneurs and individuals. We are recognized by Chambers, one of the premier law firm ranking organizations, and we were recognized in 2025 by Inc. as a power partner. In terms of what we focus on, we really are, again, focused on service and going well beyond just the individual case. Getting individual cases is never been harder, but it's also not the only thing we do. It's important, but we want to think about immigration strategically and how we build programs that are effective at attracting and retaining talent, not just getting a single application approved. So everything is within the context of a larger program management. We measure our success. We are responsive. Average response time in 2025 was 4.5 business hours. We are really focused on how we are pleasing our clients and their employees. We had an NPS score over 91, which is best in class in 2025. We are here for all stages of immigration. We work on work visas and green cards. We handle global immigration so we can help companies scale, not just in the US, but globally. We're here for consular processing, so after the case is approved, getting people through the consulate and back into the US. And then we're here for compliance and litigation as well. So if there is I-9 questions, preparing for government site visits, and then if something goes off the rails, we're able to show up in federal court as well. Who am I? I'm Matt Melter. I'm one of the co-founders and partners here. I do a little bit of everything. I love working with especially high entrepreneurial clients, but I work with clients of all sizes and help build our overall program. I'm joined here by my esteemed colleague, Michael Transick, who I'll let introduce himself.
Well, thank you, my esteemed colleague Matt. Michael Tarancic. I've been a practicing business immigration lawyer for over 30 years. I've represented clients all the way from startups, entrepreneurs, investors to Fortune 100 companies, primarily in the business immigration field. Have also done a lot of work in the compliance area, and through experience have become fairly familiar, or quite familiar with global immigration processes and procedures.
Thanks, Mike. A 1 second intro. We have our own proprietary immigration platform. It's called Voyager. Really, it's designed to make sure that the narrative we're telling you about our process is consistent in terms of what you get in the email and what you find out online. And it's meant to be intuitive and easy. It's meant to make it so that questions that you don't need an attorney or a paralegal to answer, you can get at your fingertips. Where is my case? Whose court is the ball in? How do I run? Can I run a report and get information? It's meant to make it such that the service you're getting from attorneys and paralegals is focused on the things that they do best and the things that you can find information on easily or hopefully at your fingertips. All right, today we're going to do a couple things. We're going to talk about what's happening in H-1B land, and it's a lot. We're going to talk about the enforcement surge, what's happening at work sites, what's going on with the FD&S and ICE, Project Firewall with the DOL, and student visas. So Mike and I will take our focus on various issues. We'll be in conversation back and forth. Again, if you have questions, put them into the Q&A. We want to hear from you.
Matt,
and yeah,
go ahead, Matt. I was just going to say, before we get to the full agenda, and I apologize for not addressing this in the pre-call, but there is one sort of breaking news issue that I wanted to take 10 seconds, maybe 20
sure.
seconds to highlight for the attendees. I mean the immigration bar, started hearing late yesterday that USCIS has put a hold on adjudications of both adjustment of status applications and asylum applications. So for those of you who have employees who are applying for adjustment of status, who may be going to interviews in the coming days or weeks, understand that those applications now appear to be on hold. The reason that we've learned, and USCIS has not said anything publicly about this, but just from information collected through the immigration bar, is that there is now a new layer of security screening being added to those particular applications, which the agency is requiring that the fingerprints be run again. So you may see applicants getting new fingerprint notices who may have been fingerprinted already. And the way this is going to work sequentially is that everyone who's pending will have another fingerprint security screening with these new vetting requirements. And then anyone who hasn't been fingerprinted will have to wait until they're all done to get this new screening. So anticipate delays in your adjustment of status filings. Anyone who's you have as an employee who's got an asylum claim pending, anticipate further delays in adjudication. And also we'll see, we don't know the scope yet. We know the scope includes those two, but we don't know the exact scope. So be aware if you start hearing this from your workforce that here's the reason why.
Yeah, and I would just add that there's already delays and
Yeah.
applications on pause for people who are from countries that are in the banned country list. So people from everything from North Korea and Iran to Eritrea and other countries that where there's
Hmm.
basically no entry allowed right now. Those people who are applying for all kinds of immigration benefits are seeing pauses. Okay. Mm. All right, so let's talk about what's happening in H-1B. So the USAID conducted its lottery for fiscal year 2027. We're in year 2026, but the fiscal year begins October 1st, which is when the H-1Bs take effect. So it's actually the fiscal year of 2027 is when the government's fiscal year begins because of the effective date. We saw a big change this year. We saw wage level dictate the chance of selection in the lottery. So based on the wage level that the wage cleared, not what wage you are putting in the LCA, but what wage level the wage cleared. That was the question. You got the number of select opportunities of selection: four for level four, one for level one. At Melter Hellrung, we had a 51% overall selection rate in this lottery year. That's a giant change from 2025 or fiscal year 2026, where we had about a 40% overall selection rate. When I speak to other attorneys at other firms, I've heard anywhere between 45% and 61%. So this between the $100,000 fee rule and potentially impact of this lottery selection strategy, the number of selections and entries was way down. We have not received official numbers yet, but the you know you can see here that the anticipated selection rate was really ranged dramatically depending on the wage level. I would say anecdotally, this is fairly consistent with what we saw at our firm. Um, I think we actually saw probably a higher than 69% selection rate on level four. We think it's probably a little higher than the 15 to 28 on level one, just because the number of entries was significantly lower than probably the government expected based on their projections.
Yeah, and by way of just explanation, a lot of a lot of that data in that previous slide came from data analytics provided by a couple of different immigration related entities that were really trying to chop the numbers and try to get some idea of what the selection process might look like. And then, this slide, which Matt's going to talk about, really is a compilation of data reported across, several law firms and organizations that were publishing their selection results. So this is again, it's an amalgamation, and actually, I think it substantiates what you said earlier, Matt, about the level four rates. Yeah,
Yeah, one thing I would say that about this is that uh, the chance of selection, the placement of your wage level is location based. So, you know, the wages are different for roles all around the country. And so employers, as they're looking at this and they're thinking about fiscal year 2028, I think it's a really opportune time to think about where are you placing your employees. If you are a multi-office company and you have offices in different parts of the country, and the wage level would be different for impacting chance of selection, the chances of selection go up every significantly with each wage level. So if you have an office in Santa Clara and you have an office in Omaha, like it's really worth thinking about should you put that person in Omaha. If you have work remote work options where people are choosing where they live, foreign nationals should be thinking hard about where they're choosing to live. Should you be living in New York or San Francisco, or should you choose another place? It's not a forever choice, but it is going to greatly impact whether you're selected in the lottery, except unless you're exceptionally highly paid.
yeah. I mean, there are operational considerations to take there, but I'd actually just go back for just a second on that slide if we could. I was
Sure.
kind of surprised by level two. I thought the level two numbers that are being, again, unofficially reported are a little higher. And I guess I was just wondering, my own mind, is that reflecting, as you said, maybe the geography, or maybe there a higher level of master's cap in there, which got the extra layer, I mean, it's hard to say right now, but that was that was the only number that really from this amalgamation that kind of stood out to me as being sort of outside
Yeah. And
expectations. So
it's also I'll be curious to see if they release data on how many people were submitted in each wage level.
Right. I mean,
Um,
I
I
and
mean, at our firm, we honestly didn't submit that many level one wages.
right.
Um, a lot of employers, we were having conversations about, can you move to level two? Is it, if someone's going to get a raise in November, can you be willing to move that to October? Um, how far away are you from the next wage level? So,
Mhm.
there was a lot of those conversations, and I also think that maybe some employers who historically have been the heaviest level one users, perhaps some of those like IT consulting companies, took a step
Mhm.
back from participating this year.
And most of you may know this, but USCIS does not just select 85,000 petitions in the registration process. Their data analytics has predicted over the course of the last several years the number of selections that they have to make to result in 85,000 approved petitions. So I just from eyeballing, recent statistics, they probably selected about 100,000, maybe a little bit more. So that would lead me to believe that the number of registrations this year was probably around 200,000, maybe 225. So a big drop from last year, which was 344,000.
Yeah.
So
The next piece of the H-1B, this is nothing short than like potential like paradigm shift in H-1B adjudication. And I want to just caution here that we are at a very early stage of analyzing what this means, because the USCIS is only right now starting to issue inquiries. So let me give a little background. For April 1st, USCIS released a new Form I-129. That's the primary form that goes into an H-1B petition. The first time they have asked information about how the wages in the LCA are calculated. So, what level of education is required, how many years of experience. Historically, with H-1Bs as a specialty occupation, you will only need to define in the H-1B petition what the degree requirement is. At Melter Hellrung, we have never disclosed more information than we have seen as the statutory requirement. And so we have only put in what degree the employer requires. We've never listed anything more about experience needs, special skills, anything else. We've always left that kind of information to the perm. Now the USCIS is asking for this information specifically. And we filed a petition early using this form to see what would happen where we didn't disclose this information. We got it approved, but there was an RFE not to our office, but to their law firm that we just saw, I believe, on Thursday, uh, saying that asking for this because it wasn't disclosed in the petition. So this is as I said, a paradigm shift in what's going to mean. It's going to mean for employers to think about consistency between H-1Bs and perms. It's going to require us to think more about consistency across positions and how we define LCA data. Uh, just putting it out there that this is a shift. Melter Hellrung attorneys are starting to work with their clients about how this should impact them, how to prepare petitions. We have not created uniformity and strategy across the firm yet. We are working on that diligently. So be prepared for another webinar specifically on this topic because this is really a major shift in how H-1Bs are being adjudicated, and it's going to require a lot of different type of preparation for us to be successful.
yeah, and just to add on to that, this came about through a pretty low profile change to the I-129 form. This was not, widely publicized by the agency as a significant change. It was sort of embedded not even into the core I-129 form itself, into a data collection supplement. And I think the purposes are fairly obvious. They're trying to connect the information that was provided on wage level in the registration form with the petition and with a future maybe potentially a perm application. And that's why there's just a lot of depth here that has to be analyzed. And it's hard to come up with, as Matt said, a one size fit all answer. So we're looking really hard at this and trying to figure out how to navigate this new requirement because it does appear from that RFE that the agency is going to be pretty aggressive in requiring this information.
And honestly, the type of advice we're going to give is probably going to depend on the company too, and what their exposure is and how many applications they file. Inconsistencies between two applications are pretty easy to explain. Inconsistencies between 50 applications for the same position are much harder. So, if you have a small immigration program and you file infrequently, like, do we need to worry about creating absolute consistency across everything? Probably not. It's probably easy to get through explanations on. If you're a company with a large immigration program, this is going to require a lot of work in all honesty.
Yeah, I think your comments address two issues: the risk profile and the urgency of the matter. So, maybe a smaller client with fewer H-1Bs is less risk, has a smaller risk profile and maybe a little bit less urgency. Yeah, yeah,
Right. And so we're gonna, there's a lot for us to assess and our clients to assess. But just be on aware that with this, it's going to change what we're asking for. We're expecting an increase in our fees. We hope that we are not going to experience denials. We are diligent in preparing and being ready to respond. But we also know that the USCIS is scaling up its site visits with FDNS. That's the fraud detection, and I forget what the N is in fraud detection. Mike, do you
not
know?
national. It's Fraud Detection and National Security Directorate, I
Uh,
think, is the full name of that age. It's a stumper. I've forgotten it on many occasions. So,
see,
um,
and so that's the part of the USCIS that does visits to employers. We expect that these number of visits going up, but it also means that the kinds of questions that those officers might start asking on those site visits are going to change too. So we're going to there's a lot to do here to prepare employers for compliance.
Yeah, one other thing that's ramping up in addition to FDNS is the agency. I just 30 seconds on the agency's use of artificial intelligence. DHS just signed a 5-year $1 billion contract with Palantir Technologies that'll do two things. It will help them collate and organize these massive amounts of data they've been collecting over decades, and then integrate that across agencies because so much of the information within DHS and their sister agencies, DOL, DOS, has been siloed. So it's not been easy to access this information. That is an ongoing project, which adds yet another layer of complexity into the analysis that we're going to be doing. So, um,
All right, Mike, I'm
so,
gonna
so I think,
hand it
yeah.
over to you to talk more
Uh,
about this enforcement surge.
I think in that context, I mean, this is actually a great sort of transition. Is that um, there is and we've talked about this a couple of times before in these webinars, which is ICE audits and worksite inspections are increasing and they're continuing to increase. So as you can see, just in the past year, the number of ICE officers has over doubled. It's more than doubled, right? So you've got twice the number of officers. So, having to keep them busy and engaged, there are going to be a dramatic increase in the number of I-9 investigations, audits, and site visits. So I think, what I thought I'd do just at the outset here is just to give an update on what happened in Minnesota. I had the opportunity to spend a little bit of time with one of the attorneys who was working regularly and works in Minnesota, who was representing clients pretty frequently up there just a week or so ago. And he was trying to give me information. There's been a massive increase in I-9 audits up there. He said something like 1,000% increase year over year in the number of I-9 audits. Again, reflecting the fact that there are many more officers available, and also reflecting the fact that there was Operation Metro Surge that was very prominent in the media a few weeks back. So they were just producing the I-9s and distributing them as fast as possible. They were even circumventing standard procedure by FedExing them. Usually the procedure is to deliver them by hand or by certified mail, but they were so eager to get out these I-9 audit notices that they're just dropping in a FedEx envelope and sending them out. So there's definitely an increased focus on the I-9 documentation. Why? Because it provides them access to things like employee home addresses. So if they find someone, and they did this in Minneapolis, if they find someone who is apparently, for example, using a fake green card, then they're going to go to the home address listed on the I-9 and detain the individual. And then not only are they going to detain the individual, they're going to remove them. They're going to move them from, say, Minnesota to Louisiana for expedited removal. And really, I think I highlight this because these things had massive workforce continuity impacts on employers in that region because they just happened with absolutely no notice. So this is part of the reason why it's even more important, I think, now than it was even just last year when we started talking about this, to really have a plan in place in the case notice of inspection and I-9 audit. A couple of things highlight really quickly, unusual. These notices of inspection were instructing employers not to terminate employees who had questionable status, which if you stop and think about that, the government is telling you to continue to employ someone who is apparently unauthorized. I would be careful about doing that, frankly. I think it was also there were just aggressive and expansive subpoena requests. So moving on from this issue, I would also want to highlight there was, in addition to what happened in Minneapolis, in addition to this sort of organic increase in audits, there was recently, again, a low profile, not widely publicized change in how I-9 violations are categorized. So historically, there was a distinction between substantive audits and procedural audits. And in essence, procedural audit issues, I should say, were issues that did not affect the validity of the employment verification process. So failure include a date of signature, a failure of the HR rep to include their title. These were easily correctable issues that did not impact whether or not the work authorization of the prospective employee was verified.
And just
Now,
to
yeah,
clear,
go
these are
ahead.
things that were in place, Mike, for like 30 years.
Right,
We're
right.
not talking about just like recent changes or anything. These are things that the agency had
Hmm.
been
Right.
saying were procedural for decades.
There was a memo from the late 90s from the former INS general counsel that highlighted the distinction that I just outlined. We're going to treat the serious stuff as serious stuff, and we're going to treat these procedural and technical things as issues that, frankly, you can get a 10-day correction notice for. You can actually make the corrections, initial and date them, and maybe get off with a warning notice and not a fine. Not anymore. These issues, I'm not going to go through them all, but they're there for you as a reference material to show you these are the kind of things now that have to be re-examined, right? And then in addition to the form itself, right, there are some other issues like using the Spanish language form when you're not, when your employees are not in Puerto Rico. I've had circumstances where I've seen US employers, in the Midwest, because their workforce is primarily Spanish speaking, use that form. That was not an egregious violation as long as the verification showed that the workers were authorized, right? Now it's a substantive violation that just could ratchet up the fine amounts. So I think that's the one thing that I want to highlight out of those. But you can see there's also, when you're using the alternate procedure, if you're an employee that has remote workers and you're using the alternate procedure, failing to tick that box, which is a minor procedural issue as a matter of common sense, is now going to increase the potential substantive violation amount per I-9.
And there was no real explanation as this did not occur by regulation, which is honestly sort of shocking that they didn't
Oh no,
formally put it
no,
through the Federal Register. It's just a highly
and oh
technical issue, but it's a little surprising that they're trying to ding employers so hard, but after years of not.
well, it's sort of, if you will, to use the cliche, it's almost like the perfect storm. They have all these extra officers, they're going to be doing all these extra I-9 audits, and now they're going to have all these extra factors that they're going to be able to use to ratchet up the per fine I-9 amounts, per I-9 fine amounts, excuse me. So, and again, here are a couple other things that are important. Many employers, particularly those who were doing paper I-9s, would staple the passport or staple the driver's license and the social security card directly to the I-9 as proof of the validity of the verification process. And that was something that could be used to correct the error and avoid a fine. No more, no more. Having legible copies doesn't appear under this guidance to be a factor that would reduce a substantive violation to a procedural one. They're also looking at electronic I-9 systems to make sure their audit processes will document clearly, if there were changes to an I-9 corrections, who did it, when they did it, and what they did. And if the system doesn't accurately document that, they're issuing violations there. I think, the most important point I want to make out of this particular slide is that these kinds of violations are cumulative in nature and determining the amount of the per I-9 fine. So you can see the amounts there range pretty dramatically from 288 to 2861 per form. If you've got now hundreds and hundreds of additional potential, omissions that were procedural now substantive, there's massive potential liability. So what do we suggest? I think, even if you've audited your I-9s recently, it's probably worthwhile to go back and now really focus in on these newly substantive fields. And before I go any further, one question that was raised when these changes first came out is, does it really make sense to do proactive I-9 auditing? And I think the answer is probably now more than ever, because your I-9s are going to be locked in terms of your exposure from the date of the notice of inspection. So it really being proactive, cleaning these things up and being able to present them as errors that were identified and corrected and remediated actually is probably the only thing you can do now to review the exposure. Again, standard procedure. If you're fixing omissions, you initial and date them. You use the date that the change is made, and then again, legible copies are going to be of very little help in a fine proceeding.
And I think it's also a time, Mike, to just also assess the totality of your I-9 process flow. Like, what is the process? Who is involved? What's the training? How well documented is your I-9 process? What software are you using? And I will just throw out another, a tip that, E-Verify Plus is available now, which if you are already an E-Verify user, you might consider joining E-Verify Plus. E-Verify Plus will auto-generate I-9s for you. It's very hard for me to figure out how you can get fined for the I-9 that the USCIS creates. So if you're looking for an out from these liabilities, using the government's own tool that has no cost, um, may be a really good solution.
Yeah. And E-Verify has improved dramatically over the years as an effective tool to actually screen the employment verification documentation that employees provide. And self-check is actually beneficial from, I think from my perspective, from the employer's perspective, is that it shifts a lot of the burden onto to the employee in terms of tentative non-confirmations and just keeping the information up to date. So yeah, E-Verify Plus is I think a really positive addition from the employer perspective. Okay,
So let's
so
talk about going from ICE to DOL.
yes, as we continue on this enforcement train today, we've talked about Project Firewall now. I think at a couple of different webinars, and it was an initiative announced last year, and it really is DOL, EEOC, other organs, DOJ, working together to investigate claims that the H-1B program is discriminating against U.S. workers. So situations where, and we can talk about this a little bit more, where companies seem to have a preference for H-1Bs over U.S. workers. And, when this happens, if this happens, the consequences are really very significant. I mean, there's back pay to the U.S. workers. There are civil fines baked into the program that can be significant, six figures. And maybe most importantly for employers that do rely upon a global workforce, debarment, inability to file petitions for H-1B workers for up to a couple of years. So really having a dramatic impact on your business continuity. So and you can see the fines there can be very significant. So moving on. Yeah. So what's the data tell us? So dramatic increase in enforcement actions via Project Firewall within the past few months, 48% increase. One of the big reasons is that before these investigations were primarily lead driven, i.e. someone filed a complaint against an employer or an organization. And now the Secretary of Labor can certify complaints for purposes of engaging in investigations. So what does that mean? So we don't have direct data on who they're investigating and who they're not investigating, but media reports suggest right now they're focusing on the high volume H-1B employers. And we all know those names. It's the Amazons, the Microsofts, the Googles, the Metas, the IT consulting companies. So they seem to be the primary focus of this effort, simply because they have the largest potential volume of violations, I would suspect. The other area, I think, is where third-party placements are involved. And again, that's the IT consulting community, but not exclusively that, right? So looking at those areas to make sure that, the job that is represented in the petition is the job that the individual is performing on the ground, and that the documentation aligns. And the third other area, again, just because they're worried about U.S. worker protections, are situations in which there's a layoff in a particular occupation affecting U.S. workers, which at the same time the company is hiring either in the same or similar occupation H-1Bs. That's going to be a huge red flag here. Again, and as well as the issue of benching, and as Matt mentioned earlier, the issue of wage discrepancies across occupations. So, if there's a wage level discrepancy, you have the same job in New York, Chicago, and Santa Clara. If the wage level is, and the salary, can easily be different, but if the wage level calculations are different, that's probably also going to be a red flag. And again, I just want to highlight AI and data analytics are being incorporated at a rapid pace into a lot of these investigations. So a lot of this information is being generated from all of the data that has been compiled by these agencies over the past few years. So if we have time, I just want to say, a lot of these investigations start with a public access file. And while we actually help our clients prepare, the public access file, that's not where the investigations are beginning and ending. But in connection with public access files, it's really important to do the basics, like having the file separate and immediately available for review. I think the standard is typically 24 hours, and making sure that you've retained all them that you have, and gotten rid of and purged all the ones that you don't need to keep. But those are just some basics. So, um, what else can we say? I think again with the additional resources and focus, um, there are more on-site investigations, and one of the issues that has appeared apparently in some of the investigations is really, again, sitting down with the worker and talking to them independently about what their role is, and has their role changed materially, such that maybe there needs to be an amendment of an H-1B petition or changes to the LCA public access file. And if that hasn't happened, that's an issue, right?
Yeah.
And the agency is, again, they're looking for nitpick errors here. Their violation strategy here is almost strict liability standard. There's no explanations or exceptions that are being provided.
So a couple of tips to people: just
Yeah,
make
yeah.
sure you talk to your attorney when people are terminated, so your petitions are withdrawn, and your back pay liabilities. Make sure you talk to attorneys when people are changing jobs to check whether it's a material change and an amendment is needed. Talk to attorneys when people change locations, even if that location is just someone moved from, down the block. If their work site is their home, compliance is reposting your notice of filing in the new work location. And it's as silly as is to notify the people living in the apartment that, yeah, they're doing it, but that is compliance, and it's important that those steps be taken.
And let's face it, there are lots of silly things we do in U.S. immigration law. That's just one of them. So some best practices, I think, sort of following on what Matt just said, so this is sort of broken up into three areas. First, I would sort of categorize as the defensive steps that, we should be considering, which is, if auditing LCAs for internal consistency, making sure the information in the petition is matching what's going on from a payroll perspective, and treating any discrepancies in the two fields of data as a high priority issue, because that's going to be sort of the low hanging fruit for these project firewall investigations. And I think also in anticipation of these site visits, making sure that you've audited the position description for these H-1B workers on at least a somewhat regular basis, to make sure that there is that constancy or consistency in duties in advance of a site visit. Once you're at the site visit stage, it's really hard to maybe manage some of that information and make sure that it's updated and correct. And then on the other side, I think maybe in addition to defensive, maybe more proactively, right? Because Project Firewall is really targeting U.S. worker displacement, document your process for recruitment. Most of the clients that I've dealt with throughout my career have an infinitesimally small number of H-1B workers. You have 500 or 600 employees maybe 15 or 20 or 25 are H-1B workers, and documenting the fact that there's a perspective issue here, right? You're hiring aggressively, you're recruiting you workers at multiple levels, and you're supplementing your workforce with foreign nationals really on a need basis, on a specific need basis, and really trying to make that case so that there's at least a foundation that, rather than focusing on the 15 or 20 cases, that you focus on the 500 or 600. And then lastly, training. Again, this issue we've discussed in prior, making sure that when that site visit happens, there's a procedure, for working with the government, and first and foremost, making sure that no H-1B foreign national speaks to a site investigator without consulting the company.
Mike, forgive me for if I'm putting you on the spot. We didn't discuss this before the webinar, but did you see the new DOL rule about proposed rule about joint employers that came out?
I did. Actually, I was contemplating drafting a blog for one of our newsletters on that, but there have been so many other things that have happened in the
So
last 2 weeks.
there's no
It's sort of
shortage of
worked its way
news.
that's worked its way down the line. I think that could have a big impact
Yeah.
on companies that have.
And just
Yeah,
to
go ahead.
back up because I didn't define it, the DOL, this is irrespective of immigration, this is just an overall Department of Labor rule. It's talking about joint employers and is an employer, especially if you have a contractor who's at your work site, when are you potentially on the hook for certain pieces of this? If like if you are employer A and a contractor from employer B works at your work site, contractor B, if the company B doesn't end up paying the contractor and the person's working 40 hours a week at your office, could you be on the hook for having to pay
Hmm.
that person? That's sort of the question. But I think that it plays into not from an H-1B sponsorship piece, but if you are an employer that you have contractors who are on H-1B and you're not the sponsor of, I think that could go play significantly into the U.S. worker displacement with that new rule in place, if it
Right.
goes in
I think,
place.
yeah, I think it impacts H-1Bs as well as H-2Bs in industries where there are companies that actually serve as sort of employment agencies for entities that want to use those. And IT consulting is an obvious area where, there's now the risk, maybe the heightened risk of co-employment issues arising in terms of those workers. Now, the good news is it's a notice of proposed rulemaking. So nothing's going to change imminently, it may not even change this year, but it does have here's a sort of a tangential rule that could have a big impact on a certain number of H-1B and
And,
H-2B workers. And it could also be if you're contracting with a consulting company, right? It could impact your operations as well.
yeah, and I imagine that because this is not an immigration specific rule, that the notice and comment and fight on that one will be fierce. Uh,
Right.
Employers and like the Chamber of Commerce and all kinds of other organizations are going to be not happy about that one.
All right. I think it's your turn, Matt.
All right, let's talk about student visas. Students have been at the forefront of a lot of issues with immigration crackdown. They were in the news a lot earlier in 2025 as people who were getting uh, caught into all kinds of nets about, political speech and criminal issues and all kinds of stuff. Um, but a couple of things that to really be aware of. Uh, DHS just in March issued a formal warning regarding STEM OPT, really focusing on IT staffing and consulting companies and, really what is in the training plan. Um, you know, for I-983 purposes, that's the form that you fill out for STEM OPT. It doesn't really get reviewed by much of anyone. Like if it goes to the schools are like, it looks good enough to me, that's fine. And they'll issue an I-20 to people on STEM OPT. So it's not really government review at the I-93 level. It can be reviewed potentially in an RFE on STEM OPT application. It can be reviewed by site visit from Immigrations and Customs Enforcement. So I think that really, if you are an IT staffing company or you do any kind of placement, third-party placement, and you have people on STEM OPT, thinking more about what your training plan um, is and who is doing it, and do we need a second again to that co-employment issue? Is there how are you documenting who is doing the training? Really is important on this because I think that staffing companies might be at the focus of um, potential investigations for I-983s. And just one small tip on I-983s, just make sure that you at your company, there's one person who controls them. Often they're put together by a manager. Make sure HR or immigration compliance or whoever is involved in these processes knows where they all are, because if ICE comes looking, they're going to ask for all of them, just like an I-9 audit. So don't let them be sitting in different folders someplace that you can't find them. Um, And with this in mind, we're hearing of more news of RFEs on OPT and STEM OPT applications. Some of it is about the work, some of it is about things totally unrelated to work, about what the student was doing in school. Um, Again, to the AI questions, like what was happening in terms of speech or work activities in school, potential criminal issues. Um, from our perspective, it's just something that employers should have greater visibility on. Uh, Historically, employers have just sort of let students and people on OPT and STEM OPT handle this all on their own and just said, you'll handle it, you'll pay for it, you'll get your EAD. That's the end of the story. Um, we have not seen a lot of RFEs in our office yet, but we are hearing more anecdata from across the immigration bar about this. So it's something that we are thinking employers should at least be involved in, making sure that employees are, putting applications together, being more thoughtful on the I-983s. On my end, I don't think it's worth having Melter Hellrung draft your I-983. I think that's a waste of your money. Do I think it's worth paying us, for like 0.2 hours to potentially review your I-983? Yes, I do. Um, I'm, I'm an attorney, but so don't take my word for it. But like that's my view, is that it's worth getting a set of eyes. And if you're going to be, creating the same I-983 training plan for, you know, 15 different people in the same role, no reason for an attorney to review each one of them. Review one template and be done with it. But I think that is money well spent.
But I think where the real friction is making sure that that training program is adhered to. I think that's what the agency is looking to in a large respect. So,
Right. Yeah, I think that's really important. And that on the I-983, there's also performance review pieces. So making sure that there is compliance with whatever you are stating is in your training and supervision plan, and also that the required performance reviews are occurring is really important.
mhm.
Uh, so again, you can be these uh, inspections occur without announcement. Someone would just show up, but the enforcement risk is there, and it can potentially result in someone who's on OPT or STEM OPT losing work authorization. So it is important that employers take a more visible role in ensuring the compliance with these plans and being thoughtful about what you're putting into it. Don't overpromise on something in your I-93 that you don't believe you're going to deliver. Like, far better to be vague or simple and overperform than it is to overpromise and not follow through on
Mhm.
what's in the form. Um, that's from an employer perspective, there it's just be important to, so you're having any kind of layoffs, just note that people are eligible for 90 days of unemployment on OPT, 150 days cumulative on STEM OPT. That includes time on OPT. Um, that it is valuable to, if you are any kind of position where someone is going to be furloughed or laid off, and you're rehiring, to be cognizant of whether or not you're triggering these. You don't want to necessarily hire someone back in if they're going to be post their uh, employment because they really shouldn't be in have any work authorization. It's not something that the schools do a phenomenal job of monitoring, but just remember also, if you are a STEM OPT employer, it is your obligation to notify the school yourself if you do lay someone off or terminate them. It's not just the employee's responsibility. And just as we've talked about with like ICE visits and with uh, DUL visits, have a standardized site plan, visit response plan. Your site visit response plan does not need to be different for ICE visits or DOL visits. Like to me, a well-designed plan is all part, for all of these agencies is one and the same. And truth be told, it might be part of something you designate with your general counsel or overall HR team. These are not unique to immigration. Like there are other state enforcement agencies that could come by with their State Department of Labor that have nothing to do with immigration. And to me, it's important that you have a practice or policy of how you're going to respond to these things if someone comes, no matter what it is. It's not limited to immigration.
Yep.
So,
I just have a couple of just sort of follow-on comments here on the student visa issues. One, um, the director of USCIS, Joe Edlow, has made it clear on multiple occasions that he does not believe in the concept of postgraduate optional practical training. So part of this effort, I think, is coordinating with DOL and other agencies to try to constrain optional practical training and really you know enforce the obligations to the highest degree. I wouldn't be surprised if there is a regulatory effort, and OPT is a regulatory animal, to remove or restrict it in the months ahead.
yeah.
And in
Uh,
that same, oh, go ahead, Matt. Yeah.
Oh, and I was going to say, it was only in the Obama administration that we lengthened STEM OPT from 17 months to 24 months. So we're used to a 24-month world at this point, but it wasn't that long ago that was 17 months. And, it can easily be scaled back or
Yeah.
terminated, which would be tragic, but it's something to be aware of.
And then final point for me at least, before we go to Q&A, is that anticipate that regulation that was going to eliminate duration of status for F and J students will be published in time for the next academic year. Kind of surprised we haven't seen it yet, but there's a lot going on at the agencies involved in publishing regulations right now. And yeah, I would say if they give a 60-day implementation date, which is the norm, we're probably going to see it in May, because then it'll be effective in July and will actually be in place to impact admissions of F1 students. And that's it. I don't know if we have any questions. I looked earlier. I didn't see anything teed up oh wait, now there are. Okay.
There's a couple, not too many questions. We've had only, I think this is some complicated topics, and we've had a small number of questions.
Okay. All right. So there we go.
Um, Thank you for everyone who attended today. As I said, these are evolving issues. We'll continue to keep people apprised of what's happening, abreast by our newsletter, and our blogs, and these webinars. As I said, especially on the H-1B issue, that's a target that is evolving, and we are, coming to our own synthesis of information slowly. So talk to your personal attorney for more information about how it affects your company specifically, but we'll be sharing more generalized guidance in due time. Thank you very much for everyone who's been here. It's been a pleasure having you, and we'll be following up with anyone who we didn't get questions answered to afterward. Thank you, Mike.
All right. Thank you, Matt, and see you all next month. And are we out? Oh.